There's a part of your VA rating that doesn't pay you. It pays the people you leave behind. It's called dependency and indemnity compensation. The short name is DIC. Two different doors lead to it. One depends on how you die. The other depends on what you were rated while you were alive. That second door is a clock. It's running right now, whether or not anyone's ever told you about it. So here's what's ahead, what DIC actually is, and the two ways your family becomes eligible for it. Then the one filing mistake that closes the second door for good, what it pays, who counts as a surviving spouse, what else comes with it, and the deadline your family will be on. This is the Veteran Field Manual. Plain English VA benefits, straight from the rules, with nothing to sell. Everything here is educational only. It isn't legal or medical advice, and these rules do change. Subscribe so you don't miss the next chapter. Let's start with what this benefit actually is, because it isn't the same thing as your compensation. DIC is a monthly payment the VA makes to a surviving spouse, a child, or a parent, because a veteran's death was service-connected. Your disability compensation stops when you die. DIC is a separate benefit that starts after. It's paid monthly and it's tax-free, the same way your compensation is. It isn't survivor's pension either. Those are two different benefits, and your family doesn't collect both for the same death. When a veteran dies from a service-connected disability, the VA shall pay DIC to a surviving spouse, children, and parents. That word, shall, is doing the work. When the conditions are met, this isn't a favor, it's an obligation. One condition sits underneath everything else. The discharge for that period of service has to be under conditions other than dishonorable, or the veteran died while still serving. The first door we'll talk about is the direct one. The condition the VA rated you for is what took your life. That door opens two ways. Your service-connected condition was either the principal cause of death or a contributory cause. Principal cause is the straightforward one. Your service-connected condition was the immediate or underlying cause of death. It counts whether that condition acted alone or together with something else. Contributory cause is the one worth understanding, because it reaches deaths the first path doesn't. Here, the service-connected condition wasn't what killed you. The question is whether it helped. There are three ways to show it: that it contributed substantially or materially, that it combined to cause death, that it aided or lent assistance to the death. There's a floor underneath that, though. It isn't enough to show the condition casually shared in producing death. There has to be a causal connection. One group of conditions gets treated differently. Those are the ones affecting vital organs. If a service-connected condition affects a vital organ and it's rated 100%, debilitation may be assumed. Now, the honest other side. Minor conditions, and conditions that don't change over time, usually aren't held to have contributed. Even at 100%, a muscular or skeletal condition that stays quiet generally won't carry a death claim on its own. So on this door, the medical evidence decides it. Somebody has to connect the rated condition to the death in writing. The second door is the one this episode exists for. It gets earned years before anyone ever uses it. This one opens even when your death had nothing to do with your service-connected condition. Even though a veteran died of non-service-connected causes, the VA will pay death benefits in the same manner as if the death were service-connected. You could die in a car accident. Your family can still qualify. What opens it isn't how you died. It's how long you were rated totally disabling before you died. There are three qualifying periods. The first is 10 years. The veteran has to have been rated totally disabling continuously for at least 10 years immediately before death. The second one covers veterans rated totally disabling continuously since they left active duty and for at least 5 years immediately before death. The third one is for former prisoners of war. For them, the period is 1 year immediately before death. Notice the same word in all three: continuous. A total rating that dropped and came back doesn't run the clock straight through. Totally disabling doesn't only mean 100% on the rating schedule. Total disability based on individual unemployability, or TDIU, counts here too. Rated as totally disabling includes total ratings based on unemployability. You don't have to argue that point. Now, where that clock starts. The effective date on your total rating does two jobs. It sets your back pay, and it starts this clock. Two veterans with the same rating can end up in different places, purely because one of them pinned an earlier effective date. One limit applies to this door. The death can't have been the result of the veteran's own willful misconduct. That's a defined term, not a judgment about how a veteran lived. It means conscious wrongdoing or a known prohibited action. It has to be deliberate or intentional, done knowing the probable consequences or in reckless disregard of them. And it only counts if it caused the death. Willful misconduct isn't determinative unless it's the proximate cause. A minor infraction doesn't reach that bar. A technical violation of police regulations or ordinances isn't willful misconduct on its own. There's a protection built in too. If the service department already found the death wasn't due to misconduct, that finding binds the VA. One part of this needs saying carefully and plainly. That's a death by suicide. For suicide to be willful misconduct, the act has to be intentional. And a person of unsound mind can't form that intent. That distinction does real work. The act of suicide is itself considered evidence of mental unsoundness. So where the evidence shows no reasonable adequate motive, the act is considered to have resulted from mental unsoundness. In plain terms, a death by suicide doesn't start out treated as misconduct. It starts from the opposite place. And in all instances, any reasonable doubt gets resolved in favor of the veteran. And if you're the one struggling tonight, dial 988 and press 1. It's the Veterans Crisis Line, and it's answered any hour. Two more are worth covering. The first is alcohol. Simple drinking of an alcoholic beverage isn't willful misconduct by itself. And diseases that come from chronic alcohol use, whether out of compulsion or not, aren't treated as willful misconduct origin. Isolated and infrequent drug use by itself isn't willful misconduct. Progressive and frequent use to the point of addiction is. This is where families lose a benefit they thought was waiting for them. The veteran had to be receiving or entitled to receive that total rating. Everything turns on what entitled to receive means. Read loosely, it sounds like your family could show after you're gone that you would have qualified for a total rating. That isn't what it means. Entitled to receive has a narrow, specific definition. Entitled to receive means the veteran filed a claim for disability compensation during his or her lifetime. That's the first requirement, and it's absolute. On top of that, one of three narrow circumstances has to be true. The VA made a clear and unmistakable error on a claim the veteran filed, or service department records turn up that existed back then and were never considered, where the veteran actually held the continuous total rating and the VA simply wasn't paying it for a listed administrative reason. If a veteran never filed a claim while alive, this door doesn't open after death. That's the whole of it. That's the whole lesson of this episode. The claim you file today is what your family stands on later. That reaches increases too. If you never filed for a higher rating, you never held it, and a rating you never held never started the clock. Now, what DIC actually pays? The figure you'll see written down and the figure that lands aren't the same. The base rate for a surviving spouse is $1,699.36 a month. That base doesn't change with the veteran's rating percentage. Every qualifying surviving spouse starts at the same number. If you look it up yourself, you'll see a different figure, $1,154. Both are right. That's the base number, and cost of living raises have carried the paid amount above it over the years. From there, amounts get added on. The first one we'll cover is the 8-year provision, and it adds $360.85. It applies when the veteran was rated totally disabling for at least 8 continuous years, immediately before death. And there's a second condition written into the same sentence. Only the periods when the veteran was married to that surviving spouse count toward the 8 years. So a veteran can hold a total rating for 8 years and the spouse still not get this add-on if the marriage didn't cover that whole stretch. The next add-on covers children. $421 a month for each child under 18. The next one is aid and attendance. It's the same $421, and it's about the surviving spouse's own health. It applies if that spouse is in a nursing home or is blind or needs the regular aid and attendance of another person. The next one is housebound, $197.22 if the surviving spouse is permanently housebound by disability. The last one is a transitional amount, $359 a month for a surviving spouse with a child under 18. It only runs for the first 2 years after entitlement begins. It's there to carry a household through the hardest stretch. All of these figures are the ones effective December 1st, 2025. They change with every cost of living raise, so confirm them on the VA's website. These rates apply to survivors of veterans who died on or after January 1st, 1993. If the death was earlier, check the rate for that period. Now let's cover who the VA counts as a surviving spouse, because being married isn't automatically enough. And the answer isn't the same for both doors. Each one has its own marriage test. For door 1, where the death was service-connected, there are 3 ways to qualify. You only need one of them. First is the simplest. You were married to the veteran for 1 year or more. The second is that a child was born of the marriage or was born to you before the marriage. Then, no length of marriage is required at all. The third path is a window. You married the veteran within 15 years after the end of the period of service where the fatal condition was incurred or made worse. That window runs from the end of that service period, not from the veteran's death. Door 2 is stricter. The 10-year clock has its own marriage rule. There, you have to have been married for at least 1 year immediately before the veteran's death, or have had a child born of the marriage or born to you before it. The 15-year path doesn't open door 2. It works for a service-connected death and not for the 10-year clock. The remarriage rule changed in 2021, so this one is worth walking through carefully. Generally, remarrying ends DIC, but there are 2 ages where it doesn't. The number you'll see quoted is 57. If the surviving spouse remarried on or after December 16, 2003, at age 57 or older, DIC continues. There's a second prong, and it's newer. If the remarriage happened on or after January 5, 2021, the age is 55. So which age applies depends on when the remarriage happened. Before January 5, 2021, the threshold was 57. On or after it, 55 is enough. If you read somewhere that the number is only 57, that source predates the change. Check the date of the remarriage first. And there's one more way back in. If a remarriage itself ends by death, divorce, or annulment, it won't bar DIC unless that ending was obtained by fraud. DIC isn't only a spouse benefit, children and parents are named too. When there's no surviving spouse entitled to DIC, it's paid in equal shares to the veteran's children. Parents can receive it as well, but their version works differently. Parents' DIC is based on income. As a parent's yearly income goes up, the monthly payment comes down. Above the limit, it stops. For one surviving parent, the maximum is $842 a month, and that maximum is paid at the lowest incomes. The amounts differ for 2 surviving parents. The income limits run from roughly $8,000 to roughly $11,000 a year, depending on the situation. A parent who needs aid and attendance can have $458 a month added. DIC isn't the only thing a qualifying death opens. Several other benefits attached to it. First one is CHAMP VA, the healthcare program for family members. It covers the surviving spouse or child of a veteran who died from a service-connected disability or who had a permanent and total service-connected disability at the time of death. It's for families who aren't already eligible under the military health system. You don't hold both. The second is Chapter 35 education benefits, and it turns on the same 2 doors. We've built a whole episode on it, so we won't repeat it here. The third one matters if you retired from the military and it changed in 2019. If you retired and elected the survivor benefit plan, your spouse's annuity used to be reduced by the DIC amount. A law signed in 2019 phased that reduction out over 3 years. On and after January 1st, 2023, the full annuity is payable. Eligible spouses receive the survivor benefit plan and DIC together. The last one is burial. For a death from a service-connected disability, the VA pays up to $2,000 toward burial and funeral expenses. That amount doesn't move. Unlike the compensation rates, it isn't adjusted for cost of living. There's one more clock, and this one belongs to your family after you're gone. A surviving spouse or child applies on VA. Form 21P 534EZ. The parent uses a different form, VA, Form 21P 535. If the claim reaches the VA within 1 year after the date of death, payment runs from the first day of the month the veteran died. File after that year, and payment starts the day the claim is received instead. The months in between are gone. The intent to file form covers DIC as well. It holds an effective date open while a survivor gathers what they need. So let's bring this back to you, today, while you're the one who can still act. File the claims you've been putting off. Nothing about Door 2 works if there's no claim on record from your lifetime. Read the effective dates on your decisions. Those dates are what the 10-year clock counts from. If an effective date looks wrong to you, that's worth challenging now. It's much harder to fix after you're gone. If you're at a total rating, holding it continuously is what carries this benefit to your family. And put your paperwork somewhere your family can find it. Your decision letters, your marriage certificate, your dependents' documents. The people you leave behind will be filing this while they're grieving. Every document you organize now is one they don't have to hunt for. Before you go, thank you for your service and for sitting through all of this. It's a lot to take in, and you showed up for it. If this helped, or you learned something new, share it with a veteran who could use it. Like it so more people find it, drop a comment if it cleared something up, and subscribe for the next chapter. If you want all of this in writing, the whole field manual is free at veteranfieldmanual.com. Free chapters and free tools to help with your claims journey. Nothing to sell. This is the Veteran Field Manual. Take care of yourself out there.